Good afternoon, everyone. My name is David Jacobs. I'm president of DC LERA in Washington, DC. Welcome to the national members of the Labor and Employment Relations Association and the local members of DC LERA. The Labor and Employment Relations Association, which you probably know, is a nonpartisan national organization in which professionals representing all the factions and stakeholders of the labor relations system interact and share ideas about practices in the field. The organization was founded in 1947 as the Industrial Relations Research Association. It's a forum for dialogue, for collaboration, and sometimes for argument. DC LERA is the DC area chapter. We have monthly webinars. They used to be in person. They'll soon be in person once again. And I look forward to meeting you at the Democratic Club, which happens where we ordinarily meet at DuPont Circle in the future. We will have some sessions upcoming. The in-person one that's upcoming in June will be at the ILO for a meal and a viewing of a movie on 9 to 5, the workers' organization, with Karen Nussbaum, a founder of the organization, and Lane Wyndham, who has written about it and works at the Kalmanovitz Institute. So I have the pleasure of introducing Steve Sleigh, who is past president of National LERA, as well as past president of DC LERA. He'll be introducing our guest, who is Ernie DuBester. Let me say, please register, and please become a member of DC LERA if you haven't already. And Steve, take it away.
Thank you, David, and a great intro to DC LERA, and we've got a really good crowd of people today, so thanks so much. We hosted a bunch of these webinars in 2021 and pivoted quickly in 2020 to do them virtually as well. And so we've sort of gotten used to doing these virtual meetings, but as David said, it'll be great to get everybody back together and see people in person. Today we have a really great speaker, and I'm going to just moderate this conversation and just try to move it along. We'll leave plenty of time at the end for questions, last at least 10 minutes, hopefully 15 minutes for questions. So if you have a question, sort of hold it until the end. But today we have Ernie DuBester, who is the chairman of the Federal Labor Relations Authority. He's been there since 2009 and was the chairman fairly recently. He has a long career in labor management relations. And as I like to do in these conversations, I like to just set the context of understanding the people that we're talking to. So I'm going to ask Ernie to give us a little bio. He could talk for hours about what he has done. I could talk about him for hours of what he's done, but I'm going to ask him to do that in a few minutes, and then to really talk about the labor relations in the federal sector. Not everybody knows how extensive the workforce is, and unionization and the issues that the FLRA faces. So Ernie, just with that as sort of a tee up, if you could give us sort of the short Ernie DuBester story.
Well, good afternoon. It's great to be with you all, and appreciate those of you who signed up and come out. And I know David's spoken to it. I want to just add my appreciation for LERA, National LERA and DC LERA. Been around a long time. I've been a supporter for a long time and active off and on, but I think it's a particularly important time right now to have a forum like this that brings together diverse views in a nonpartisan way, and so I really appreciate what you do. And I've been very fortunate. So I was talking earlier with one of my law school classmates, and I know he's on, and I'll just say that when I was in law school, probably 90% of the subjects we all take, if we're lawyers, I didn't have any interest in at all. Certainly labor management relations, labor law was one of them that I was, and I've been very fortunate to have a career in that field. One of the reasons in all the areas that I was interested in, part of the attraction for me beyond the substance was that it involved with working with people. And I've, again, been very fortunate not only to have great experience in labor management relations, but with rare exception to me, just an unbelievable number of very great special people. And so I feel very fortunate to have had the career I've had, and I hope that for the younger people that are on, who have an interest in labor management relations, that you will have a lot of joy in your career. So I've worn many hats, as we say. And some people, some of my detractors would say I've had trouble holding down a job, but I've done, I don't want to say I've done it all, but I've done a lot. I've been fortunate to be an advocate. I've been a neutral, as a mediator, as an arbitrator, and I've been a teacher and a trainer. And I've taught collective bargaining and arbitration. Most recently, when I taught full time, I actually headed a dispute resolution program, and I taught subjects like negotiation, mediation, alternative dispute resolution. And of course, right now, and for many, many years, I started in this realm, and I'm currently in this realm. I've been a public servant, and public service to me is a virtue that I'm very proud of. And as part of my public service, I've had the privilege for over 20 years now at 2 different federal labor relations agencies to be in a leadership position. And that is a privilege, and it's a challenge. And I will say right now, because we're going to focus, at least I am, we're going to focus a lot on what I'll call the institution of collective bargaining. I want to also point out that in my leadership positions, which now again involve over 20 years, I've also had the responsibilities of a manager. So for those of you who are out there who happen to be managers or supervisors, I will just remind you that for over 20 years, I performed a lot of the tasks or had a lot of the responsibilities that come with being in a management position, like responsibilities for budgets and responsibilities for performance, and including on occasion discipline, and responsibilities for staffing adequately to perform successfully mission, and even in some cases to deal with the challenges of consolidations and reorganizations. So while, as you'll hear, I am certainly a believer in collective bargaining and the virtues of labor organizations as part of that process and institutions, that doesn't mean at all that I'm anti-management, quite the contrary. So that's about as short as I can be, Steve, but
But let me just recite sort of the alphabet soup of labor-related agencies that you've been at and had senior roles. You were at the NLRB, National Labor Relations Board. You were at the Railway Labor Board, which is a separate from the NLRB, which covers workers in the transportation sector.
National Mediation Board, yeah.
In the National Mediation Board.
So the National Mediation Board is what you're referring to with the Railway Labor Board, yeah.
Yep, and now currently at the Federal Labor Relations Authority. So, Ernie, tell us about the FLRA and sort of paint the picture of the federal workforce. I think not everyone knows how extensive unionization is in the federal sector, or the diversity of employees that are in the federal sector.
Sure. So, as I've often said over the years, the FLRA is a small agency with a very large mission. We have jurisdiction over the civilian workforce, or most of it, subject to statutory exclusions, and that consists of about 2 million employees. And the federal civilian workforce, contrary to a lot of kind of stereotypes, actually work in about 350 different occupations. And that includes blue collar workers, people who maintain our heating, cooling systems, clean our offices, build bridges like sheet metal workers. It includes technical employees like scientists and engineers. And of course, it includes a large number of people in administrative or professional, including lawyers, I have to say, that probably most people are more familiar with. I say the FLRA has a huge mission because I've always said it has rippling effects. In our statute, we are directed, the FLRA is directed to provide leadership over the labor management relations programs of all the federal agencies over which we have jurisdiction, which is most of them. And so our ability to do our job and to help them really can have a direct effect on their ability to perform their agency's mission, because labor management relations problems can be a distraction that can often undercut that. And I'm going to get into some more because the FLRA is going to be eventually the core of my remarks. So
yeah. And so in paint a little bit of the picture of unionization in the federal sector. Who are the big unions? Who do they represent? And sort of what are the statutory differences between union representation in the federal sector versus the under the NLRB?
All right. Well, that's kind of my whole presentation, Steve. But let me seriously, but let me say this. Let me start with extent of organization. So you mentioned the National Mediation Board, where I served in the 90s, and that agency oversees what you referred to, the Railway Labor Act, and it covers both the airline industries and the railroad industries. Those are probably the two most heavily organized industries in our country. The railroad industry being well into the 90%. And I haven't seen figures for the airline industry recently, but it probably is close to 70%, I would say, or somewhere thereabouts.
Yep.
So the federal sector, I would say, is probably the sector that's probably the most heavily organized after that. So that would be our jurisdiction. And again, this varies for different reasons, but I would say in terms of actual union membership, it probably hovers between 35 and 40% of the federal civilian workforce. And I don't have the data on the number of collective bargaining agreements throughout the federal sector, but it's quite extensive. And the largest, well, there are many unions, and I hate to start to mention them because I'll hear from the unions that I don't mention. There are a lot more unions in the federal sector than probably most people are aware of. I'll just say that. I mean, certainly the two unions that have the largest representation or membership would be the American Federation of Government Employees and the National Treasury Employees Union. But then there are a lot of other unions that represent workers, and including but not limited to the National Federation of Federal Employees, the International Federation of Professional and Technical Employees, the National Association of Government Employees, our air traffic controllers, which is a hybrid situation, but they are represented. And of course have a union, NATCO, the Air Traffic Controllers Association. And now I'm kind of feeling badly that I even tried to answer your question, because whoever it is I left out, I'm gonna hear from them tomorrow, and I apologize. But there's a large number of unions in a group called the Federal Workers Alliance. I've mentioned some of them, and some of them are, in addition to, well, the International Brotherhood of Electrical Workers are part of that. They represent federal employees too. The National Education Association has an affiliate, the Federal Education Association. So again, to those of you who I haven't mentioned, I apologize.
So why don't you go ahead and talk about the thing that you like to talk about the most, as being a leader of a big agency like this. You know, people, relationships, effective communications. That's been the Ernie DuBester story for years, and so have at it, man.
No, I appreciate it, and I guess let me start this way, because I want to set the table and I want to provide context. I'll remind some of you will know, some of you wouldn't even know this, but about 10 years ago, I wrote an article for the LERA magazine, Perspectives on Work. And it was part of a public policy forum on the future of federal sector union, public sector unions. And my article was entitled "Collective Bargaining as a Critical Value of a Democracy." It's about 10 years old. What I did in that article was I traced our country's history going back to post-World War II, when General Douglas MacArthur, who by the way was a Republican, the Republican Party was trying to solicit to run for president. But when General Douglas MacArthur in post-World War II was in Japan trying to resolve the situations at the end of the war, and what he was doing was he was working on the Japanese constitution to make sure that it ensured for workers and union rights. And I traced our history, our country's history, from then right through the Arab Spring of about 2012, through Republican and Democratic administrations alike, stopping midway, say, for President Reagan's administration, where he made many, many speeches abroad, also promoting workers and the rights of free trade unions as part of his promotion of democracy overseas. And my point is, we've had an historical bipartisan tradition until recently, but we've always had that tradition of promoting worker rights and the rights of free trade unions in our promotion of democracy abroad. Now, of course, recently, ironically, democracy itself has come under questions and concerns, not only in our country, but perhaps around the world. And I will just say, to me, it's always been very unfortunate that we've had this kind of disconnect between our promotion of democratic values abroad with the realities of, for whatever combination of reasons, and there are several, but I would say certainly the polarized political situation in our country, where it tends to take on more of a partisan cast. I think that's very unfortunate. And I'll just say one more thing before I move on. You know, in my article, the one thing I pointed out, for those who do believe in democracy and do not believe in authoritarian governments, you know, early on, I quote from the scholar Hannah Arendt on totalitarianism. And she points out that the existence of free trade unions is one of the 2 or 3 hallmarks of a democratic country and a democratic nation. So that was just kind of the context for that. And I think, you know, here in this country, as you pointed out, Steve, or I mentioned indirectly, I've had the pleasure, and it's been a pleasure for me, to work at all 3 of the federal agencies that oversee our 3 federal collective bargaining laws. And now, for the last 13 years, thankfully 13's always been my lucky number, I've had the privilege to work at the FLRA. And in recent years, most of my life, it was the private sector and the NLRB that always tended to be the focal point for what I'd call a lot of the political hot button items, if you will. And not so much the FLRA, at least not after the heated debate that took place about its creation in 1978. But in recent years, collective bargaining in the federal sector and the federal workforce have quite frankly been under siege. It's been a unique time and a challenging time. And certainly the tone of that changed with President Biden's administration, and President Biden very early on issued an executive order on protecting the federal workforce. But I'll share with you that it also has included my service at the FLRA in recent years, because there's been an effort by my colleagues, which I say respectfully, because in keeping with the LERA traditions, to me, it's a serious time to discuss ideas, and it should be around ideas and policy. But nonetheless, my colleagues have had a purpose of overturning longstanding precedent, to me, changing the parameters of collective bargaining as I believe it should be in the federal sector, and it's led me to dissent quite a bit. And I will just say, for those of you who don't know, that for the moment at least continues 15 months into the Biden administration, because I'm still in the minority. I am the only Democrat among the 3 members of the board. So now, let me just turn to my remarks, Steve. So I have them right here in my pocket. As people know with me, I always have them next to my heart. And here they are. It's the Federal Service Labor Management Relations Statute. It's the statute that created the FLRA. And I point to that because I think it's important to provide context to evaluate what I just referred to. Because I think this is a very serious moment, a time of inflection, even if you will, for federal sector labor management relations and collective bargaining in the federal sector. So let me start right here on page 1. And Steve, you told me we have till what? We have till dinner time for this?
To the end of lunchtime.
Okay. So right here on page 1, and let me just say here under findings and purpose, Congress finds that collective bargaining in the federal sector safeguards the public interest, contributes to the effective conduct of public business, and facilitates and encourages the amicable settlement of disputes. Excuse me. And it says, and therefore labor organizations and collective bargaining in the civil service are in the public interest. Now, I believe that, but it's not just that I believe that. That is the foundational public policy statement in our statute. But then, as I always say, when you're evaluating what this is all about, context is important. I'm all about context. And so let me provide the context. What I always say about our statute, when people start to nitpick over particular items and raise concern, is this statute to me, of course, it's got legal implications, but to me, it's a carefully crafted policy statement that considers, if you will, the unique attributes of not only public sector bargaining, but specifically bargaining in the federal sector in a way that's distinguishable, say, from the NLRB in the private sector, which a lot of people are familiar with. So let me just quickly run through some of those unique attributes to set the table for context. 1, in this statute, a much narrower scope of bargaining than exists under our private sector law. Many important matters that are mandatory subjects in the private sector are prohibited in this statute. And moreover, the duty to bargain does not extend to matters addressed by any government-wide rule or regulation. For example, wages and fringe benefits, Those are huge items, of course, in the private sector. Second attribute in this federal statute, a specific, detailed statutory provision on management rights. On management rights. Now that concept, as you all know, exists in the private sector, but there's no statutory provision on it. And within that provision, ironically, you have the basis for what I would say is the most prevalent kind of bargaining in the federal sector. In the private sector, you'd refer to it as effects bargaining. In the federal sector, we call it impact and implementation bargaining. And it comes up and arises in the management rights provision as exceptions that require bargaining in certain circumstances over either procedures or appropriate arrangements. And I'll just say that, and I don't want to get too technical. I want to make sure we try to keep everybody awake during the lunch hour. Third, very important attribute. Again, in contrast to other sectors, and particularly the private sector, there's no right to union security in this statute. In the private sector, as those of you know, that's the basis on which unions are able to exist and perform their representational duties. That right does not exist under this statute. What do you have instead? You have a concept called official time. It's the basis for this statute working. It's the basis certainly for unions being able to perform representational activities that collective bargaining entails in a lot of things. And official time is one of the areas that is often the subject of criticism by detractors of the statute. I will say in the prior administration, there were 3 executive orders directed towards the federal workforce, and one of them specifically was addressed towards official time. But again, official time, if you believe in federal sector collective bargaining, is the key to it being worked successfully. And also, I might add, and it's not unfettered or unlimited, under our statute, it still has to be bargained. In the section on official time, which is section 7131, it requires that unions, we call exclusive representatives, and management officials, agency reps, have to bargain over appropriate limits of time. And then finally, let me just say, another unique attribute of the federal sector is there's no right to the use of economic weapons. Unions do not have the right to strike. So then I have to mention the one other, as a consequence of all those things, the one other piece that becomes so uniquely important. It's important everywhere, but it's uniquely important to the operation of this statute. And that's the importance of arbitration, and particularly the grievance arbitration process to the statute. One, grievance arbitration provisions are mandatory in the federal sector. They're required by this statute. Every collective bargaining agreement has to have one. In the private sector, most of them do, but it's not required in the same kind of way. There are technical legal reasons why they do. Required under the statute. Grievance is defined in the statute in a very, very broad way. It encompasses many, many, many things. Our experience at the FLRA reaffirms what I'm saying. Arbitration cases, because we handle, like the NLRB, we handle unfair labor practices, we handle, we handle representation matters, similar to the NLRB. Those are 2 that are similar. We also handle a category of cases called negotiability kind of cases. which is a public sector concept that's unique to us. And then fourth, we handle appeals from, if you will, or we call them exceptions, from grievance arbitration awards. That's unique. And in fact, we sit as the surrogate for the federal courts and the private sector. And those kinds of cases, arbitration cases, are always a significant majority of our caseload. And the percentage of arbitration awards that are appealed to us is dramatically higher than the historical appeal of arbitration awards in the private sector, which is about 1 or 2%. In the federal sector for the FLRA, historically about 20 to 25% of arbitration or awards are appealed. The other thing I'll mention is, and our statute provides this, the parties, the labor management community in the federal sector, can take exception from arbitration awards on one of two bases. One is on all the grounds that are recognized in the private sector. But secondly, and this is unique to federal sector arbitration, they also can take exception based on the fact that the award allegedly violates a law, rule, or regulation. So not only do arbitrators, when they're doing federal sector work, have to police the collective bargaining agreement, which is kind of their traditional province, they also have to oversee laws, rules, and regulations to make sure their awards work. Having said all that, I think the statute makes clear, I think the policy underpinnings make clear that when the FLRA is considering exceptions from arbitration awards, that basically arbitrators should be accorded the same deference that they're accorded in private sector arbitrations. And I think that's very important, as opposed to, now we consider exceptions to the law, rule, or regulation de novo. But again, even there, I think there's an amount of deference owed. But that has become a bone of contention in recent years, where over my dissents, often disagreement, the spirit of the LERA tradition of airing conflicting ideas. And I want to say it's not just my point of view. And I will point out that like in a number of other cases recently, the DC Circuit in July of 2020 issued a decision called National Weather Service, in which they tracked a dissent of mine in part, but they basically did say the FLRA is required to apply the deferential standard of review used by the federal courts in the private sector. And I will say it was interesting. Usually, the FLRA is the last resort on grievance arbitration appeals. In this case, the court had jurisdiction because the matter also involved an unfair labor practice. And so that gave the court a jurisdictional hook to consider the matter. But that's a very important case. And for those of you who, let's say, have an academic interest, I'll just say quickly, it's reported at 966 Fed 3rd, page 875.
Ernie, we got a couple questions coming in
Sure,
too.
go ahead.
But I wanted to ask you about the structural question first. It's 2-to-1, and what is the process for Biden nominating and getting the Trump folks off the board? What is the procedure for terms and that sort of thing? Sure.
Well, again, under this statute, and it's always been this way, there's always a requirement that one of the three members if you will, be from the political party that's not the occupant of the White House. So, for example, during President Trump's administration, I was the lone Democrat.
Right.
For decades that existed beforehand. Right now, the Republican Party is entitled to have one member as part of the three-member complement, and the president has the right and has nominated a person to be a member who has not yet been confirmed and is pending on the Senate calendar as we speak.
Yep. Okay. Here was a question that came in. Actually, Mindy, why don't Emily, could you unmute Mindy Reeser and she can ask the question?
Okay, if am I unmuted?
Yep, we can hear you.
Sure.
Okay, great. Well, this is terrific, and I'm sure lots of food for thought going forward. I'm just curious now as to what impact, I don't know what the technical word is, finding, ruling, stipulation, that federal salaries not be based on prior salary history. What impact is that likely to have on the federal sector, but even more on hiring in the private sector? I know in my own personal life, you're always asked, so what did you earn? And sometimes you might find that the new salary could be $30,000 more, but you won't get it if you didn't earn in that income level previously.
And Ernie, if you could broaden your answer to include the disparity between federal sector pay and private sector pay, in addition to this, putting sunshine on what you earned before.
Well, I'll just make a couple of observations to try to just because to me, it's a very complicated issue but I don't want to duck it. The first thing I'll remind you of relative to pay is that most, as I mentioned earlier, most salaries or most wages, if you will, are not subjects or issues that can be bargained. So just to remind you of that. So in terms of that dynamic, it's out of our control. I would say the impact is complicated. I mean, one thing is one I'm dealing with it right now. It depends on how I think about it from the point of view of attracting and retaining quality people. That's always been a focus of mine in public service. And to me, without getting into particular cases, Mindy, I would say, that's an issue that you can probably readily understand. Also, it cuts a lot of different ways, if you know what I mean. I think the disparity between public sector or federal sector pay and the private sector, I think, is a useful frame of reference. And I think it's important on the one hand, particularly in moments when I think the federal employee is being the target unfairly of a lot of accused or suggested ills, which I do not think are true. But on the other hand, what I would say is, and this is why I think context matters, there are a lot of attributes, and I would even say benefits or virtues about being in the federal sector, if you will, that kind of offset deficiencies, if you will, in a relative sense with regard to salaries. So I think that has to be kept in mind. And I would say that probably the most significant one there, among others, would be the whole realm of healthcare. I mean, depending on where you are in the private sector, being able to afford healthcare, again, depending, can be a very challenging and costly undertaking in recent years. I think we're very fortunate, not even though it's been getting more and more expensive, that at least the federal employee, generally speaking, has pretty good opportunity for having access to good healthcare coverage. And then right now, I mean, I'm an advocate in wage increases. We just got a wage increase approved by President Biden. For people like myself who have to deal with budgets, the ironic contrary effect, which doesn't cause me to oppose them, is that eats up more money that we're then allocated for in our budget, and perhaps precludes us from being able to do other things we want to do, including in the aggregate, hire an employee or two. So it's a complicated subject, but at the end of the day, however it plays out, I'm always centrally concerned about a lot of things, but centrally concerned about what I would say is a fair and accurate acknowledgement that recognizes the dignity of the federal worker.
Yeah, good, great. Jeff Wheeler has a question, and Jeff was intimately involved with bargaining issues when he was at the Department of Labor. So Emily, if we could unmute Jeff, and Jeff, take it away.
Thanks. So yes, the FLRA is a very important agency. I'll say that as a former AFG Local 12 president. There were a couple of issues I was wondering about. One is the FLRA had a union, and the Trump administration revoked recognition of the union, throwing the staff into a bit of turmoil. So one, I was wondering what happened there, or that was reversed. And the other is Judge Ketanji Brown Jackson wrote an excellent decision reversing or invalidating large parts of the Trump executive order, which was then reversed on appeal. And but this, what seemed to many of us a crazy question, which was the whole dispute had to go to the FLRA for determining the constitutionality of the president's executive order. So has that issue gone away, or is that still kind of hanging out there, that the FLRA would be charged with determining whether the president's executive orders would be upheld? And I don't know if you can say anything about Judge Jackson, but it'd be interesting to hear your reflections on that too.
So two questions there. One, what happened to the staff union at FLRA? Yeah, and then executive order.
So let me start with that. So as you said, Jeff, actually for the first time in the FLRA's history, going back to 1979, because back in 1979, the FLRA recognized an in-house union, and that was based in part on a thoughtful legal memo done by the Department of Justice, which basically made it clear that the FLRA could voluntarily recognize an in-house union, even though it was one of the statutory exclusions, the FLRA, from our own statute. And since 1979 until 2018, through Republican and Democratic administrations alike, that union had existed and been recognized and bargained or discussed with, if you will. When I became chair which was the first day of the President Biden's administration, the very first thing that I did was restore recognition of the union. And I think there were several reasons. Number one, I thought it was the right thing to do. Number two, I will just say, as people who know me know, if you look at our statute again, and you look in the section called Powers and Duties of the Authority, in the very first section, it says that the FLRA is required to provide leadership, as I mentioned this before, provide leadership in overseeing labor management relations programs throughout the federal government. It says that before it even gets into the cases that we have to handle, like unfair labor practices and represent the ones I've just been talking about. To me, if that's your primary mission, and it is, then it's also a question of leading by example. I mean, it's setting an example for an area that we're talking about, of restoring recognition. And I will just add real quickly before I move to the second question. So this year, we have been negotiating with our in-house union on many matters, but particularly the matters that all of you are aware of, matters that also concern the private sector, but certainly affect the federal government, like amount of telework, circumstances around remote work as a separate concept from even telework. Now negotiating over a plan of reentry or return to the office. These are very important matters that are challenging all of us, and we're negotiating with our union. And let me just say, I have a lot of experience negotiating. I'm not at the table, I'm the chairman, but you know, bargaining is tough. It's not easy. I'm not saying that, but I think it's the right thing to do. And it's giving voice, not only to our employees through a union rep, but ideally it's giving voice to managers and supervisors too, on the other side of the table. And so I think it's the right thing to do. Moving to Judge Jackson, I'll just say quickly a couple things. One is, yes, when she was with the district court, a district court judge, she wrote the decision you mentioned, which invalidated large parts of the executive orders of President Trump in the areas, as I mentioned, of official time, collective bargaining, and employee, I call it discipline. We have gotten decisions that still raise the import or impact of those executive orders and are dealing with them as appropriate. I will also say, though, relative to my general theme, because I'm not going to get into all the particulars that I planned on addressing today, but my general theme about thinking seriously about labor relations policy for the federal sector going forward and what this statute should mean, given the context that I've asked you to think about, that the DC Circuit has, in addition to the one decision I mentioned on grievance arbitration awards, has issued a number of decisions, again, usually tracking dissents of mine, overturning decisions of my colleague. And one of them, I believe, was the very first decision written by Judge Jackson after her elevation to the DC Circuit. And that matter involved a case where my colleagues had overturned 35 years of precedent. And I dissented. And it's interesting, I'll just say, you know, one of the things that's going to be perhaps shocking to some people who know me, but I think it's important to realize this. I'll announce it here first. This is a scoop. I am the conservative. I am the true conservative. If you look at Webster's dictionary, who says one who tends to maintain existing views, conditions, or institutions characterized by traditional norms. In virtually all my positions on law and policy and collective bargaining, that's what I'm trying to do. Maintain precedent, maintain longstanding traditional norms that have governed labor management relations, and certainly is, like the one I mentioned earlier, deference to arbitrators when they're handling grievance arbitration awards. That goes back to the Supreme Court's decisions in the Steelworkers Trilogy, among other things. So I just thought I'd add that to my my responses to Jeff on Judge Jackson and the in-house union.
Perfect. Ernie, if you could talk a little bit about some of the sort of contemporary issues we've heard in a lot of our other presentations here over in 2021. We had a great presentation, for example, by Harold Meyerson, who writes for the American Prospect, about the increasing labor militancy. We see a wave of strikes. We see organizing at Starbucks. You know, a lot of activity on the labor side of things. Do you see that in the federal sector as well? Is the federal sector workforce agitated and worked up, and how are they expressing that?
Well, you know, again, there are some contrasts that you're all aware of. and some of our some of the traditional abilities to, if you will, engage in self-help, or as I said earlier, use economic weapons, those are prohibited under this statute. I think, to me, what I would say, I'd say a couple of things that I point out, and I guess, and I don't know if we're running out of time. One is, to me, and this is my view of collective bargaining, Steve. If I had to say simply, what is the virtue of collective bargaining? Is it's all about dialogue. It's all about talking to one another. It sounds so simple and basic, and it's not that. But it is simple and basic if you're talking about, are we talking to one another or are we not? And so I'm all about giving voice. That's reflected in my restoration of the recognition of the in-house union that I mentioned. As a manager, as the head of an agency, would it be simpler for me not to have to negotiate with the union? Yeah, it would, quite frankly. Do I think that's the right thing to do? Obviously not. And I think it's important to give voice, but it's also important to represent fairly and openly the point of view of management, if you will, and to empower my managers. So I would say there's a lot of pent-up frustration in the last few years. And I know that exists throughout the federal government. And let me explain another way, Steve. So for several years during the administration of President Obama, we had a National Council on Labor Management Relations. And we had the concept of labor management forums. They were designed to be a complement, if you will, complement with an E, not an I, a complement to the collective bargaining process. But they provided another mechanism for agency reps and union reps or their employees to sit down and get together and problem solve. And I think it doesn't matter to me whether they happen to be part of a President Obama executive order or not. Those kinds of mechanisms that promote dialogue, to me, are effective. And so within our agency, to deal, one thing that I've also done that I think is very important, and to me, I think I need to mention, that also was abolished in 2018 for the first time at the FLRA in 25 years. I restored it, was our CADRO office, our Collaboration and Alternative Dispute Resolution Office. It had existed since the 90s. It came in shortly after a congressional law called the Administrative Dispute Resolution Act, which encouraged and required all federal agencies to create ADR offices. Our CADRO office has now been restored, and I think it's the kind of office, to me, that number one is consistent with our exercising leadership to help the parties, but provides an invaluable service in so many different ways when there are problems, and there are always throughout the federal government between unions and management. And they can intervene in a variety of ways, by providing mediatory or facilitation services, by problem solving with the parties and helping them. Again, one of the great virtues of CADRO and ADR generally is successfully, it enables the representatives from the labor management community to be the decision makers, to work things out on their own. And that's one way, as opposed to the agitation that you reference elsewhere, that I hope we're making an impact. And I will also point out, because I'm running out of time, but I'd be remiss if I didn't mention it, because this is another component, if you will, that is such a critical substitution for the absence of economic weapons. And that's our Federal Service Impasses panel. as those of you who practice know, I mean, they get involved in collective bargaining disputes. And usually after perhaps the intervention of the Federal Mediation Conciliation Service under our statute. And the reason why I want to mention them is not only because of the importance of their role, but we have recently in the last few months a new panel, and it's a panel with a lot of both labor relations and dispute resolution experience. It's chaired by Marty Mallon, who's served at the FSIP previously, who has a lot of experience himself as an arbitrator and a mediator, and of course, a lot of, until recently, great impact and success academically at Chicago Kent. But the reason why I want to mention them is they have decided to use the process of grievance mediation initially. I mean, of MED-ARB, I'm sorry, of MED-ARB, mediation arbitration, with their initial handling of collective bargaining disputes that come before them in the federal sector. Now, before my time at the FLRA, I had quite a bit of experience with MED-ARB, and I love it. And what do I love about it? Well, first thing I love about it is because it starts with MED, the mediation part. And again, it affords the parties the opportunity to be the decision makers without having to resort to a third party decision from an arbitrator or other adjudicative tribunal. And I know that MED-ARB was a preferred process during the panel's work during the Obama years. And I will tell you that they had a success rate of getting voluntary settlements, I want to say over 60% of the time. So I wanted to mention that because I think that's so crucial. And again, going forward, I appreciate that. But for the parties, you should support our cadre office because they provide a great assistance. And to me, it's not an office that should be a political football. It's an office that should have labor and management support at any moment in time to promote dialogue between the labor and management communities and to help them solve their own problems in a more effective way. And I'm sorry to run on. So.
No, that's great, Ernie. And we are unfortunately out of time, but this has been a fantastic conversation. I do want to mention, and I'd like to have Emily put in the chat box, LERA is doing its national conference. It'll be virtual in June. And would really encourage people to sign up for that. A lot of these issues will be talked about, but Ernie, in all seriousness, you know, the country is a better place because you're doing what you're doing, and I just think it's really important that more people hear about these kind of proactive, positive steps in labor management relations that you are initiating and you're really leading. And I think it's just a great thing. And just I thank you, and I'm sure the rest of DC LERA thanks you for joining us today. And we look forward to seeing you in person. Dave Jacobs, I'll turn it back over to you as if you have any final words as we wrap up. But again, Ernie, thanks so much for not just joining us for today, but for your long career and for what you do.
Well, thank you. I enjoyed this today.
Thank you, Steve, for moderating, and thank you, Ernie, for participating. Great presentation. I appreciate that. Dave Schlein has a question. Why don't you email me, Dave Schlein? I'll get the question answered for you at dcjacobs@american.edu because we're closing down now. And I look forward to seeing all of you at the next meeting next month. You'll have details about that forthcoming shortly. Thank you very much.
Enjoy San Francisco.
Thank you. Flying above the bridge. Thank you, Emily and Bernadette, for your help. And thank you to everybody. Have a good afternoon.
Thanks
Bye-bye.
again, Ernie.